इस देश में धार्मिक युद्ध भड़काने के लिए केवल और केवल सुप्रीम कोर्ट जिम्मेवार है। सुप्रीम कोर्ट का एकमात्र उद्देश्य है, शो मी द फेस, विल शो यू द लॉ।
In a significant development on 21st April 2025, the Attorney General of India, R. Venkatramani, has approved a request to initiate criminal contempt proceedings against Bharatiya Janata Party, BJP, Member of Parliament Nishikant Dubey, following a letter from an advocate on record, ROR, seeking sanction under Section 15(1)(b) of the Contempt of Courts Act, 1971, for Dubey's remarks against the Supreme Court of India and Chief Justice Sanjiv Khanna. The controversy erupted when Dubey stated the Supreme Court is taking the country towards anarchy and held CJI Sanjiv Khanna responsible for the civil wars taking place in the country. Comments made in response to the Supreme Court's decision to set timelines for the President and Governors to act on bills, which Dubey viewed as judicial overreach.
आप जब राम मंदिर का विषय होता है तो आप राम मंदिर में कहते हो कि कागज दिखाओ, कागज दिखाओ। कृष्ण जन्मभूमि का मामला आएगा मथुरा में तो कहोगे कागज दिखाओ। आप जब शिव की बात होगी, ज्ञान वापी मस्जिद की बात आएगी, कागज दिखाओ। मुगलों के आने के बाद जो मस्जिद बने हैं उसके लिए कहते हैं कि आप कागज कहां से दिखाओ। इस देश में धार्मिक युद्ध भड़काने के लिए केवल और केवल सुप्रीम कोर्ट जिम्मेवार है। सुप्रीम कोर्ट का एकमात्र उद्देश्य है, शो मी द फेस, विल शो यू द लॉ। सुप्रीम कोर्ट अपनी सीमा से बाहर जा रहा है। सुप्रीम कोर्ट की सीमा यह है कि भारत का संविधान जिस कानून को बनाया उस कानून की उसको व्याख्या करनी है, और यदि वो व्याख्या नहीं कर सकती है और सब कुछ के लिए सुप्रीम कोर्ट जाना है, तो इस संसद का कोई मतलब नहीं है, विधानसभा का कोई मतलब नहीं है, उसको बंद कर देना चाहिए।
He further accused the court of double standards in its handling of the Waqf Amendment Bill 2024, alleging it demanded property papers for temples but not for mosques, thereby stoking religious wars, a statement that gained traction after being highlighted in a social media post by A. Rangnathan. On 19th April 2025, the Waqf Amendment Bill 2024, passed into law as the Waqf Amendment Act 2025, has been a flashpoint, introducing reforms such as the inclusion of non-Muslim members in Waqf boards, a 5-year rule for declaring Waqf, the removal of Waqf by user, and direct appeals to the High Court, provisions that have sparked protests across India, including violent clashes in West Bengal and Tripura, and led to multiple petitions challenging its constitutional validity in the Supreme Court. Under the Contempt of Courts Act, 1971, Dubey's remarks fall under criminal contempt for scandalizing the court, as they undermine public confidence in the judiciary, with the Supreme Court now expected to issue a notice for Dubey to explain his statements, potentially facing up to 6 months in prison or a fine if convicted, though defences like fair criticism or truth in the public interest may apply. The BJP has found itself in a precarious position, with National President JP Nadda distancing the party from Dubey's remarks on 20th April 2025, stating they were personal views, a move that has drawn criticism from supporters like Indic Logic and Vikram Pratap Singh, who claim 90% of BJP voters and Hindus back Dubey, warning that the party risks alienating its base, while critics such as Dr. Jan label him unfit to be an MP and user demand strong action. Public sentiment on platforms like X reflects a divide, with supporters arguing that Dubey's remarks constitute speaking the truth and that contempt proceedings reflect judicial dictatorship, while others question the judiciary's sensitivity to criticism, posting images with captions like "Where is the freedom of speech now?" A debate intensified by broader issues of judicial accountability as users highlight unresolved corruption allegations, including the case of Atul Subhash, a Bangalore techie who died by suicide on 14th April 2025 after alleging a judge demanded 5 lakh rupees to settle his case. Historically, the judiciary has clashed with public figures over contempt, as seen in the 2020 conviction of lawyer Prashant Bhushan for tweets criticizing the judiciary, the 1978 ADM Jabalpur case during the emergency, and the 2015 dispute involving Madras High Court Judge C.S. Karnan, while internationally, the UK abolished scandalizing the court in 2013 due to disuse. A contrast to India, where a 2018 Law Commission report justified retaining it due to the high number of contempt cases. As the Supreme Court prepares to hear this case, its outcome could set a precedent for handling criticism from political figures, especially amidst growing public distrust over judicial accountability, testing the delicate balance between protecting judicial dignity and upholding the fundamental right to free speech, a balance that will shape the future of judicial legislative relations in India.